You are before the Judicial Service Commission, and before you are the commissioners. I know you know all of us, but for the sake of the record, we will do a round of introduction before we begin the interview.
Very well, Chief Justice.
My name is Martha Kome. I'm the chairperson of the Judicial Service Commission.
Thank you very much.
Welcome.
Thank you.
And my name is Machere Njero. I'm the vice chair of the commission.
Thank you.
Pati Geshohi, karibu sana.
Thank you very much.
David Majanja, Judge of the High Court, welcome.
Thank you, Commissioner.
Olwande Evelyn, Chief Magistrate and Commissioner, karibu.
Thank you very much.
Jacqueline Ngutia, Commissioner, welcome.
Thank you very much.
Olive Mugenda, Commissioner representing the public. Welcome.
Thank you, Commissioner.
Mohamed Warsame, karibu sana.
Thank you, Judge Commissioner.
Welcome, Your Honor. My name is Justice Mohammed Ibrahim of the Supreme Court, representing that court at this commission. Karibu.
Thank you. Thank you very much.
Thank you very much, commissioners, for that introduction. Before we begin the interview,
Yes, Chief Justice.
I think you can tell us your county and your ethnicity.
Okay. Thank you, Chief Justice. I come from Vihiga County.
Vihiga.
Yes, and I'm Luya.
Yes. We are going to ask you questions, and you are free to seek clarification.
Yes.
Because we want it to be a very interactive engagement with you. You can begin by introducing yourself to us, stating very briefly in about 3 minutes your background, your academic and professional qualifications, your work experience, and please remember to tell us your key highlights or achievements. What makes you think you are suitable for the job we have advertised? Yes.
Thank you, Madam Chief Justice. My name is Hon Adika. I went to primary school in Langata West Primary School, and in high school I went to Langata High School. I then joined the University of Nagpur in India to pursue a degree in law, which I did in the year 1997. I then came back to Kenya and joined the Kenya School of Law, where I did my diploma in law. And on the 21st of October 1999, I was sworn in as an advocate of the High Court of Kenya. I then proceeded to the firm of Munika and Company Advocates, where I was a litigating advocate. And thereafter, I joined a company known as Kenya Grange Vehicle Industries as a legal and administrative officer. I was there for about a year or so, and I left and opened my own concern, a law firm, Adika and Company Advocates. I practiced from that firm for about 2 years. Then I joined the judiciary in the year 2005. I joined as a resident magistrate. I was posted to Mombasa. We remember very well that time was the time when there was a problem with the magistrates, and Mombasa was quite affected. So when I went there, we were only 3 magistrates. I worked there from the position of resident magistrate, and I also doubled up as the deputy registrar of the High Court Criminal Division. In the year 2008, I resigned from the judiciary to pursue private practice again, but soon realized that that's not my calling, and my calling was in the judiciary, adjudicating on matters. So I then applied again in the year 2010, and I came in as a district magistrate 2 professional which was the lowest position, despite having left as a resident magistrate. I was posted to Kisumu, and in Kisumu, I pride myself for being the magistrate who started the municipal court of Kisumu. I also was the first deputy registrar for the Employment and Labor Relations Court. I set up the court, ensured all the files were brought to Kisumu, and settled the judge and the registry and the staff in there. I was then appointed as a deputy registrar of the Court of Appeal in April of 2013, when the Court of Appeal was decentralized and a section opened in Kisumu. I worked as a deputy registrar and a resident magistrate from the year 2013 to about 2017, when I was transferred to Nyeri in the same capacity as the Deputy Registrar Court of Appeal Nyeri and Senior Resident Magistrate. In Kisumu, I pride myself having started what is continuing up to now, a weekly lunch for all the judicial officers from the Court of Appeal all the way to the Magistrates Court, to just catch up, bond, and find out if there are any issues that we have. We use that as a peer review. I also started Mahakama Football Club, both in Mombasa when I was there the first time, and in Kisumu. And we used this to ensure that officers, both judicial officers and judicial staff, bond and interact so that we can have a good working relationship. In Nyeri, I replicated the lunch, which is still on up to now. Every Tuesday, the judicial officers meet to have lunch and bond to discuss issues affecting their work. I also do other roles, such as being the master of ceremony in many of the occasions that the judiciary holds, the main one being the opening of the main court of the Kisumu law courts in March of 2016. I then worked in Nyeri until the year 2019, at the advent of the COVID pandemic. Again, around that time, the Court of Appeal had closed down, so there were no judges in Nyeri, Kisumu, and Mombasa. And I was then made to be in charge of both Nyeri Court of Appeal Registry and Mombasa Court of Appeal Registry. And I would shuttle between Nyeri, Nairobi, and Mombasa during that time of COVID to just ensure that the registries are running. I also teamed up with my team leader, the Registrar of the Court of Appeal, to come up with ways and means to ensure that the court proceeded even during COVID. And one of the things that we did was coming up with the virtual hearings, virtual service, and ensuring that matters proceed even during that period. I was then made a substantive deputy registrar in Mombasa, and I relinquished the position in Nyeri. This is because when they added the judges in the Court of Appeal, a bench was set up in Mombasa and there was no bench in Nyeri. So it didn't make sense for me sitting in Nyeri as a deputy registrar with no judges, with no bench, yet Mombasa had a bench with no deputy registrar. So I've been in Mombasa from 1st of August 2021 to date, still doubling up as a deputy registrar and a principal magistrate. One of the things that I've endeavored to do in Mombasa is to beef up the registry, because when the Court of Appeal closed, most of the staff were brought back to Nairobi. So I had to set it up again to ensure that it's running and ensure that the judges are supported. I have also begun the same thing that I began in Nyeri and Kisumu, but this time I began with the lunch, a monthly luncheon for the judges of the Court of Appeal, to meet the judges of the High Court, and then we will cascade it down given time so that we can see how that works. That has been my road to up to where I am right now.
Yeah, thank you very much. We note those social skills that you have, you know, of interacting and making people interact. I want to move to another area. You know, the judiciary is about resolving disputes. So we are very concerned about your ability to write judgments, to resolve disputes, and looking at your career, you have been more into administration. So I will use this opportunity to ask you how you are going to convince us that you are the right candidate for this job when you have spent very little time writing, you know, judgments, resolving disputes.
Thank you, Chief Justice. I must state that one of the things that I was doing initially was to give the strengths that I have as a person during my career. I have been sitting in court, both in Kisumu and in Nyeri, and I've been able to resolve disputes. I've written judgments, quite a number of judgments, both criminal, civil, family, sometimes land, and lately when I was in Nyeri, and employment and labor relations. So I am capable, I have a good understanding of the law, and I've also been able to embrace the new technologies that are coming up of resolving disputes. That mainly is the alternative dispute resolutions, to ensure that we resolve these matters quickly.
So what, how have you demonstrated the independence of the judiciary when doing that work?
One of the ways that I've demonstrated independence is in my own judgments, the ones that I have written, some of which I have also given to the Commission for them to look at. I consider the principles in the Constitution while discharging my duty as a judicial officer writing a judgment. I ensure that I am only concerned with what the Constitution says, what the law says, and the facts that are before me. And it's what I have done every time I'm resolving a dispute.
And what are those principles about the independence?
The main principles that I consider are, for example, Article 10 of the Constitution. I also consider the principles, the bungalow principles, which determine how a judicial officer is supposed to operate, to ensure that he's seen as independent and not leaning to any side.
Okay. And what is the judicial philosophy that has guided you in your work?
I take myself to be a moderate pragmatist, in the sense that I do not come with a predetermined mind to a case. I wait for see the facts of the case and apply the law in the case. And I also remember that in interpreting the Constitution, we are instructed to ensure that we interpret the Constitution as if it's speaking to us. So that's why I'm pragmatic in that sense. So once I looked at the facts, apply the law, and then look at the situation that is prevailing and see whether it needs to pragmatism or not.
Is there a situation where the Constitution has spoken to you and how it spoke to you in any of these judgments?
Yes. In one of the judgments that I have supplied to the Commission, it was a matter where it was somebody had been charged under the Narcotic Drugs Act. And what I looked at was what the Constitution looks at when it's defining the society. What kind of society are we looking at when we are dealing with people who are offenders within that act? So I looked at it and I saw that there was a progressive manner in which the Act was speaking to ensure that the society is protected from such crimes.
Thank you very much. The next set of questions will be asked by Commissioner Justice Ibrahim Mohammed.
Thank you very much, Justice.
Thank you, Honorable CJ. Honorable Adika, I have a few questions for you. It happens that you right now are you hold a very strategic position as the registrar, deputy registrar of the Court of Appeal in Mombasa, and sitting in that position, you are able to monitor processes between the High Court and which come to the Court of Appeal. You know what's happening in the Court of Appeal, and you know also what's happening in the Court of Appeal, in the High Court, in the course of that work. I'd like to ask you about what you know of the vision, mission, and core values of the judiciary, with emphasis on the present motto of the judiciary through her leadership, the CJ, judiciary's social transformation through access to justice. Would you like to give me your views about that?
Yes, Commissioner, thank you for the question. The vision of the judiciary is that it aims to be an independent institution of excellence in dispensation of justice. And when I look at the STAJ, it speaks to that vision, in the sense that some of the principles in STAJ, for example, enhanced access to justice, is directly attached to the institution being an excellent institution in dispensation of justice. So therefore, when looking at the dispute resolutions within the context of the vision, one has to ensure that the principles that are enshrined in the STAJ are adhered to. Like I said, enhanced access to justice, quick disposal of cases, ensuring that the matters that are coming to court are dispensed of in a very quick manner.
Thank you. In the same lines, I refer you to Article 21 of the Constitution. Do you have any demonstrable experience from your part that shows that you have contributed to the advance of access to justice for the vulnerable members of society? Are there any examples you could give us?
Yes, like I had said before, Commissioner, at the advent of the COVID, we all know that there was restriction in movement and even interaction. One of the things that we did is to ensure that matters are heard, and that even with the COVID situation, people still accessed justice. So one of the things that we did was, when we started the virtual courts, a lot of litigants and even advocates did not have the luxury of access to either the machines, laptops and that thing, or internet, or even in a space where they can be able to do this. So we created a space within the court so that those who are unable to access it from wherever they were, we would invite them to come to court, put them in a place, and they would be able to proceed with their matters in that manner.
Okay. You're preparing or hoping to come to the High Court as the judge, and which we wish you well.
Thank you.
Are you familiar with the strategic plan of the High Court itself? The current strategic plan.
I've just brushed through. I've not gone through it in detail, but yes, I am aware that there's a strategic plan that was launched some time back by the principal judge, which details the role that the High Court wants to play within the STAJ itself.
Now, what is your philosophy? Not really for philosophy. What do you think is the role of the judiciary in national development?
I think the main role is resolving disputes, because one of the things that enhances the growth of a country is if the disputes are at a minimum level. So if we are able to resolve disputes quickly, we will be able to leave space for development to occur. And also, because disputes hold up a lot of money that is supposed to be in the economy, again, quick resolution of those disputes will allow for the release of this money into the economy, and that will enhance the development of the country.
Thank you. Lastly, many of us recognize your ability and skills of personal relations, and also of communication, and also bringing up social attributes of bringing up people together. Would you give me examples of your leadership achievements at any level in your life?
Yes. I volunteer at an NGO called Physicians for Human Rights. And one of the things that I do is educate the players within the criminal justice system to ensure that we are able to deal with matters criminal in a faster, more accessible, more friendly way. While doing that, there was a conference that was organized in London in the year 2014. And from the judicial officers who were part of the PHR, the Physicians for Human Rights, I was actually appointed to go to London, and I was made a speaker to that conference. And one of the people who were listening to my speech was one Fatou Bensouda.
Thank you very much. I wish you all the best.
Thank you very much.
Okay, thank you, Honorable CJ. Just a few questions. Now, you know, I'm struggling to understand how ready you are as a judge, because you know you took a lot of pride in the lunches that you're organizing and all that, but you know, at the end of the day, what you want is a doer of the core duties of a judge, which is to resolve disputes.
Yes.
You know, so how, because you see, I'm still not getting where you've shown us that you are ready to do the job, and you might end up going there and organizing even more lunches for judges, which will remove them from their core duties. So explain to me, I mean, what is it that really you have that brings that, you know, ability to go and become a solid judge?
Thank you, Commissioner. I usually do not take the position of a judge in isolation. A judge is not only supposed to sit in court and resolve issues. That is his major role. But one of the other things that he's supposed to do, he's supposed to be a leader. And in leading people, you're supposed to do other things other than just being able to you know, sit in court and hear matters. But even apart from that, like I said, I have a very good understanding of the law. I have been resolving disputes and writing judgments. And to that effect, I believe I am ready to be a High Court judge, to act as a leader in the High Court, and to also assist in resolving issues.
You see, Your Honor, the reason I'm asking you that question, as it is, there's a lot of complaints from stakeholders that judges are putting off matters a lot of times to attend to other activities other than hearing matters, you know. So there's already those complaints. So you see, when I hear you now again coming and laying undue emphasis on these non-core activities, that's why it concerns me, you know, as somebody who is also you know, representing the core stakeholders. But now moving to the second issue, now again, when I look at your career trajectory, where at some point in time you had a law firm, moved to judiciary, worked in the judiciary, then again went back to the private practice and opened a law firm. I mean, again, doesn't that cause so much confusion? Now I'm speaking to the character. You know, when you are moving and opening a law firm and having clients and all that, it takes a lot of efforts. Then again, you move back, and this time even to a lower position than you are in before. So again, I'm struggling to understand how that impacts on your ability to focus on a career path that you are clear this is the way I want to move, and deliver on whatever your vision that you have. So explain to me a little bit, because I'm confused.
Okay. Things happen in life, and as things happen in life, you make decisions at that particular time based on what you're faced with. One, I must admit, I was young. Clearly, I was young, and I had ambitions of where I wanted to go, things I wanted to do. And those things included some social things that come with somebody being a human being. So my leaving the judiciary, my resigning from the judiciary in the year 2008 were caused by a myriad of issues that were happening around my life at that time. And like I said, after 2 years, I then realized that my focus should be on what I want and where I feel comfortable being in terms of my career progression. And that's where I made the shift and decided to come back to where I felt I was comfortable, and that was in the judiciary. And since I've been in the judiciary, I have committed myself to doing what needs to be done. I've grown myself as a person, both professionally, socially, to be able to handle even the pressures of being a High Court judge.
Okay. My final question is on accountability and confidence building. Because if you, as a judicial officer, and you're aspiring now to become a judge, there's the aspect of confidence building. Now, how do you think a judicial officer, or a judge for that matter, should carry themselves in the manner in which they relate with the other players in the justice system? Firstly, to infuse the confidence, to bring in integrity in the office, and to inspire confidence that the judicial officers and judges will be trusted in the very important role that they play in the administration of justice.
Thank you, Commissioner. One of the things, my guiding north towards that question is Article 1, that we must always remember as judicial officers, as a judge of the High Court, that this power is donated to you by the people. Once that is known to you, then everything else that you will do subsequent has to be towards ensuring that the power that has been donated to you is being carried in the proper manner. So one of the things that a judge needs to do is exhibit leadership qualities in terms of ensuring that you are in touch with the people that you're serving. And you can do this through CUCs, bar bench meetings, and those kind of engagements that are encouraged to ensure that we are, working on our mandate, as it were. So that's the first thing that I would do, to engage with stakeholders as much as possible to gain their confidence in terms of what the mandate they've given to us.
Thank you, Honorable CJ. Mr. Adika, you have heard about Gela versus Cusman Brown.
Yes, I have, Commissioner.
There are three principles. The first principle is prima facie case. What is a prima facie case?
A prima facie case, Commissioner, is a case which, when one looks at it from a casual look, without having to go into details, raises issues that need to be adjudicated upon.
Okay. Secondly,
Yes.
that is one of the cases which you will deal with every day, and you may have dealt it with every day. What was the real issue, the real dispute about in that case?
At the moment, I may not be able to recall the real issues that were there.
Yes.
What I pull out are the principles that came out of the case.
Okay. Okay. One of the cases you have dealt with, I have read, you have dealt with the issue of intention to commit a crime. There are certain types of cases where intention to commit a crime is not necessary. Tell us one.
Where intention is not an ingredient
Yes.
to the offense.
Yes.
Commissioner, I would think assault, an offense like an assault, you don't need to have intention.
Okay. Let's go to a case which you have dealt with. It's the case of Wanjiru Rose, the lady who was charged with 141 rolls of bang, 513 kilograms, valued at 2,820. And she was charged under Section 4A of the Narcotic Drugs and Psychotropic Substance. And you gave her 30 years imprisonment. Why?
Commissioner, when I looked at that case and I came to the conclusion that an inference of guilt was there, I then looked at the sentencing process of that section, and it said that you will fine the accused person 10 times the amount of drugs that they were found with, and 10 times the amount they were found with, or 1 million, whichever is greater, and a life sentence.
Was there a sentence now on reflection? Was the sentence you imposed lawful in view of what you have stated?
Yes, I believe it was lawful, because even on appeal, all they did was to reduce it from 30 to 10.
Okay, I don't think so, so you need to look at that. Now, let's go to election matters. There are certain jurisdictions left for a magistrate court, certain jurisdiction or certain matters left for the High Court, and then it goes certain matters left for the Supreme Court. In your view, is the jurisdiction of the High Court and the Court of Appeal in dealing with election matters concurrent or consecutive?
Just repeat the last part of the question, please.
I am saying there are certain matters within the exclusive jurisdiction of a magistrate court.
Yes.
That is the MCS. There are certain matters for the exclusive jurisdiction of the High Court, and there are certain matters for the exclusive jurisdiction of the Supreme Court. Now, there is a court that does not have original jurisdiction.
Yes.
In election petitions.
Yes.
And that is the Court of Appeal.
Yes.
In exercising jurisdiction together with the High Court, is the jurisdiction concurrent or consecutive?
My view would be it's consecutive.
Why?
Because there are matters which will come to the Court of Appeal, to the High Court on appeal, and then there are those ones where the High Court has original jurisdiction, will go for appeal in the Court of Appeal.
Okay, I wish you well. Thank you, Honorable CJ.
Thank you very much.
Thank you, Chair. You have presented 5 judgments of your judgments covering various areas in which you deal with in the magistrate's court. So I'll be asking you general questions about the judgments and issues arising therefrom. But I would also just comment to you they are straightforward, simple, and clear to whoever is reading them.
Thank you.
If you come to the High Court, you are aware that a bulk of the matters you'll be dealing with, almost 20% in criminal cases, are either murder cases or robbery with violence appeals and sexual offenses. And one of the things you will be asked to deal with is the issue of accomplice evidence. Evidence of accomplices, co-accused, accusing each other or making confessions implicating each other. And that you think you have dealt with it in one of the cases there. The question I want to ask you is this. There are many authorities, East Africa Court of Appeal, that say accomplice evidence is evidence of the weakest kind.
Yes.
Can you tell us why and how do you deal with evidence of an accomplice against a co-accused?
Thank you, Commissioner. I believe the reason why the decisions say that the evidence of an accomplice is of the weakest sense is because of the implication that that evidence is going to have upon the other accused. I can't remember the authority, but in one of the authorities it said that one must be very careful to ensure that this is not just being said, or it's not evidence that is being produced to get somebody off the hook, because somebody can use that evidence to get off and leave the co-accused with the whole issue.
How do you deal with it as a court? How do you deal with accomplice evidence in the sense that it implicates a co-accused? Say on what, or let's put it simpler, on what basis would you convict a co-accused on the basis of accomplice evidence?
The situation I would do that, again, just keeping in mind that it's of the weakest sense, is where I find that the evidence was not given in a situation where somebody wants to escape the sentence that is supposed to be imposed. I think in the one that I handed over to the commission, my finding was that when the accused gave the evidence, he was giving a truthful account of what happened. It wasn't necessarily because he wanted to implicate the co-accused.
There is normally a word we say, corroboration.
Yes.
The second is again arising out of your judgment, your decisions. Again, if you are a court of appeal judge, you will meet many of these circumstances. In one of the cases, you dismissed the suit,
Yes.
but proceeded to award assessed damages.
Yes.
Why is that important for an appellate court? That even though the suit has been dismissed, you proceed to assess damages. Why is that important if you are a judge in the High Court? That even though the suit has been dismissed, you proceed to assess damages. Why is that important if you are a judge in the High Court?
It's important because, Commissioner, sometimes you may overturn the decision of the lower court, and in overturning it, it then means that you have to have a basis on which to consider the award that you will give. So when the lower court gives you a figure and says, I dismiss, however, had I found, I would have given this, then that gives you the basis upon which to see what award to give.
Okay. And lastly, going back to the decision my colleague referred you to, it's fairly common again, you'll be dealing with appeals, and many people, many prisoners will be coming and saying to you that this sentence is harsh and excessive. As an appellate court, what do you consider if you come to the conclusion, and in fact in the case you appeal, the appellate court says the sentence was excessive? So what factors does an appellate court consider when it comes to the conclusion that the sentence is harsh and excessive?
Commissioner, I think one of the considerations would be if this was a first offender, this was the first time that they committed the offense. The second would be the mitigation that is given by the accused person. And the third, I think, I'm not very sure whether it's very strong, but the third one would be in looking at the sentencing guidelines and what they intend in terms of the prison's numbers and that kind of thing. Thank you.
Thank you, Chair.
Thank you. So, Honorable, we have two school of thoughts with regards to distinction between constitutional and statutory interpretation. There are those who believe that constitutional interpretation differs from statutory interpretation, and there are those who believe that there should be no distinction. Where would your school of thought lie, and why?
Thank you, Commissioner. I think my school of thought would be that there should be no distinction in both the interpretations, because you are interpreting a law, and the other one you're interpreting a constitution. The principles for interpretations for me would be the same. Yes.
And if you were to cite a number of constitutional provisions that would guide that school of thought?
I would say Article 10, Article 259. Yes.
Okay, thank you. Back to the question I know my colleagues have asked on the bang issue, that a person is found with bang worth 2,820, and you proceed to sentence the person to 30 years.
Yes.
You have said one of the principles you ought to look at is one of the documents that should guide you in sentencing is a sentencing guideline.
Yes.
Did you refer to this sentencing guideline at the time of sentencing this woman to 30 years imprisonment?
Yes, I did, Commissioner, and the sentence was supposed to be life. So I looked at the mitigation she had given me, and I thought instead of giving life, I give her 30 years. And I think, again, that time, we were still using the Murwatetu fiasco, and we were quoting Murwatetu extensively, and we were saying if it is mandatory, because for me I read it as a mandatory, the Supreme Court has declared it unconstitutional, but after the directions I wouldn't have gone that way.
Okay, and so you agree with the High Court decision that
Yes.
it was excessive?
Yes, I do.
Okay, thank you. That will be all.
Thank you, Madam Chair. Just one or two questions or points of discussion, and I want us to focus a little away from the law. And I've seen from the report from your referee that you are committed to public service. Very strong recommendation of commitment to public service. And Article 232 of the Constitution, they are allowed 80 values that are very key for any public servant. Would you share with us two of those values and how you promote those values where you are? Two of those values.
Thank you, Commissioner. I think one is promoting devolution.
Devolution. If you look at Article 232, I want you to focus a bit more clearly. Devolution is a good word thrown all the way, but I want you to look at the values and Article 232, and this is coming from your supervisor, that you are committed in public service. Okay, go ahead.
Because I wanted to say, Commissioner, that one of the ways that I've demonstrated this is the manner in which I've been able to carry out the process of devolution of the courts and in terms of the access to justice.
Okay.
The other one I would say is equality, where I treat every person equally. They are equal before the law, and that's the starting point before you do anything.
Okay. You aspire to go to the High Court. When I look at documents from the High Court, they have got one or two issues they call corporate identity. Corporate identity of the High Court. Would you share with us two of those those strategies that they want to promote to be able to enhance the High Court in terms of the public eye?
One of them, Commissioner, is the alternative dispute resolution, where they intend to use alternative means other than hearings of matters to adjudicate on matters. And the second one is enhancing virtual hearings, technology. And
in your opening remarks, Honorable, you talked about you are very good. You said you must have ceremonials or something of those issues. I didn't know you are aware of what a brad is, how you are notified by the public. And they are very specific. If you look at the documents they have produced here about the High Court, reputation, how it is perceived by the public. And if I can give you some guidance, enforcement of the code of conduct, how would you do that? That is one of the things they have.
Enforcement of the code of conduct would, the first and the principal issue would be to ensure that I also, as a person, follow that code, and two, to disseminate it to the members of staff and to the members of public so that they are aware.
If I come to the High Court in Mombasa, you said you are the Deputy Registrar in the Court of Appeal Mombasa?
Yes, I am, Commissioner.
What would strike me different from the other registrars in Kenya in the Court of Appeal? One thing that will strike me in Mombasa.
The one thing that would strike you in Mombasa is that we have the charter. We have a charter that is placed right before the entrance, so that you're able to know what kind of services that we give. Yes.
Good. Under the key research area of the judiciary, number 7, key research area of judiciary, again the documents they have talked about enhancing the image of judiciary. And that is really, and I'm happy that you talked about the service charter. What else did you do to enhance the judiciary's image in Mombasa under the key resort area number 7?
Commissioner, I think one of the things that I'll do to enhance the image of the judiciary is to conduct what we know as service weeks, and to have engagements with stakeholders.
Okay. Thank you, Chair. Thank you.
Yes, I have just, Your Honor, I've just checked your promotions, and I realized that even though you were hired on probation in 2010,
yes,
your confirmation came 10 years later, and yet in between you are promoted to resident magistrate, you are promoted to senior resident magistrate, you are promoted to principal magistrate. So what happened? And maybe it's not your problem, but it's good for me to know what happened.
Yes, we actually agitated for that. We realized at some point that we did not have confirmation letters. So we then inquired, and the same was done.
So it was a group of you?
It was a group of us. It wasn't me alone.
Okay. From our records, you are very, you sound like a social person. The commission talked about the lunches and all that. But how do you separate work as a judge and also your social activities, where it's very easy to get mixed up? And how do you do so to separate the two if you become a judge?
Okay. Thank you, Commissioner. One of the ways that I separate my work from my social life is to ensure that I minimize the social interactions that I have. The ones that I mentioned earlier are mainly the ones that involve the judiciary and the ones that would enhance and ensure that the judiciary works better. If we are able to reduce the friction between the lower cadre and the higher cadre, then we find that work would be easy in that sense. So that is the manner in which I try to enhance the social skills. But when it comes to the outside world, then it has to be very measured. If it is engagement with the stakeholder, then that is an engagement with the stakeholder.
How do you deal with difficult lawyers or even litigants who appear before you? Or you have not had a case where they are difficult?
There are cases where you get into a situation where advocates, I don't want to say they are difficult, but they would appear as if they are being difficult. But one of the attributes that I have is that I'm a very patient person. So I'm able to go through it slowly and be able to bring the parties to understand that we are here to resolve an issue and it is nothing personal. So it's one of the skills that I use to diffuse that kind of situation.
Okay. Thank you, CJ.
Thank you, CJ. Good morning once again, Honorable.
Thank you, thank you.
So I don't want to take a lot of time with you. We've heard what you have to say, so I'll just go straight to your performance.
Yes.
I've looked at the report we have from Depop.
Yes.
And it doesn't, your report is based on your work at Nyeri Law Courts.
Yes.
And I'm looking at the backlog situation there. It shows there's a concerted effort to reduce backlog, which is good, because out of 4,574 cases, only 315 are backlog, and only 30 are backlog older than 3 years, which is commendable.
Okay.
Unfortunately, you are not carrying your weight, because your input is in the station is 6% out of the expected 17%. I don't know what you have to say about that.
Okay. The situation in Nyeri was dire. At some point, we had 5 magistrates. We had 5 magistrates. 2 of us were deputy registrars, taking care of the registries.
So this is just judicial work. You're also doing deputy registrar work.
Yes, I double up in both.
Okay.
I do deputy registrar and I also go to court.
Okay.
Yes.
Now, I'm looking at the case clearance rate in that court. It is quite high, higher than the national average. That is, let me just give the percentage. It is lower than the national average. It is 82% against a national average of 83%. And also the productivity is lower than the national average. That is 418 out of 529. What does it tell you about the performance of that station in general, that report?
Commissioner, like I had started, there was a time when we really had quite some problem with Nyeri in terms of the personnel that were there. And that could be the reason why those figures look that way. But I want to say that in terms of even bringing the percentages closer to the ones for the national, we really tried under the circumstances that we were in. We really tried to bring it up.
What were the challenges you're facing?
Like I said, there was a time when we were only 5 magistrates. One was mainly handling the children matters. The 2 of us, one was the deputy registrar in the High Court and doing judicial work, and myself in the Court of Appeal.
So the challenge was basically numbers?
Numbers.
Okay,
yes.
Thank you. The other question I want to ask you is on case management.
Yes.
Why do you think case management is important in your work as a judge? Should you make it God willing?
I think it is essential. I think it's to me even the crux of the matter, because when you do case management, you are able to thrash out a lot of issues that usually clog up hearings of matters, so that by the time the matter is coming up for hearing, all the issues that would cause adjournments are no longer there. It also assists in alternative dispute resolutions, because at some point when you start doing case management, you realize this is not a matter that needs really to go for hearing, and for that matter, then you would transfer it to the mediation or something like that. So I think it is very important for someone to do a case management, because in that case it will help you increase your productivity in terms of delivery of justice.
Okay, thank you. And as a deputy registrar, you've served as a deputy registrar for quite a while for several courts. Do you have a role to play in case management?
Yes, in fact, in the Court of Appeal, I think we were the cogs. We do the case management, and then so that we be able to thrash out these issues. So the role of the deputy registrar is key. It's crucial in case management, because you then free up the time for the judge to be able to handle the hearings.
Okay, thank you. Now, there's an issue that most DRs have been, let me not say complaining about, but concerned about. The fact that their work input is not very clearly measured. Now, you are here representing yourself and other DRs. I just want to hear your views or your suggestions on how we can both qualitatively and quantitatively measure the work of DRs.
Thank you. I think the work of the DR truly needs to be seen more than it's seen right now. I'm not saying it's not seen. And one of the ways to enhance this is to be able to tap into the roles that they have. For example, if a DR is doing taxations, that needs to be put into consideration, because it involves you writing a ruling on that taxation. When you do case management, also that needs to be tapped in, because there are a lot of directions that you give in terms of that case management that we do. So for my view is, some of these roles that the deputy registrars perform need to be culminated into some performance index that will then indicate that they are actually working. The way it is right now is that, it appears that you really don't do anything when you spend a lot of time, say, for example, in case management or in taxations.
Okay, thank you. I want us to discuss briefly on corruption.
Yes.
You have not been working in any specific court. You've been doubling up in several courts as a DR.
Yes.
So I don't want to peg you to the report that we received from Nyeri. But I just want to get your views in general. The corruption prevalence index in the judiciary is at 7.03%. Really, the ideal situation should be zero, because we keep preaching about zero tolerance to corruption. So what ideas would you have that would help us maybe bring this to the desirable figure of 0%?
Commissioner, if I may use an analogy, they usually say if water drips in a certain place for a long time, it creates a hole. So for me, one of the strategies that we should have is to keep on speaking about this vice as much as possible until we create a dent within the institution. The second one, of course, is the reporting part, that we should continue encouraging reporting of these matters whenever they happen. And then my other view is also the engagement with stakeholders is very, very important, because sometimes you as a judge or as a judicial officer may not know that this vice is there, but the stakeholders may bring it to your attention that this is happening within your station. So that would be a good way of also curbing the vice.
Okay, thank you. Lastly, on community service,
Yes.
I've seen in your CV you said community service is a hobby, but you've not given us a lot of details. What exactly do you do in terms of community service, and why you think it is important to participate or engage in community service?
Thank you, Commissioner. I believe, my own self-belief is that I must give back to society. When I look at where I've come from to where I am right now, I think I'm very privileged, and I'm lucky to be where I am. So I do this as part of giving back to society that has nurtured me to where I am. So it's not something that I'm forced to do. It's something that I do out of my own free will. to the extent that it is almost a hobby. One of them is, for example, I managed to organize a football match between judicial officers and prisoners in Shimolatewa, with the then, may Lord rest her soul in peace, Commissioner Wanini. And it was just to be able to, just show the community that we are human and we think about them, we mind and go through whatever they go through.
So other than the football match, anything else you do for community service?
Yes, recently after I applied for this position, I was appointed to sit on the board of Mbale Boys, that's a boys' school next to my home. So we are planning a lot of activities with the boys just to ensure that the boy child doesn't get lost. And then the activities that I do with the Physicians for Human Rights, that's training, and I do a lot of training even for my colleagues, magistrates.
Okay, thank you. I have looked at your vetting documents. They are okay. We have reports on your background. The reports are not bad. You have a good grasp of the law. You have a listening ear, just like you have said. You have good administrative skills. You have well-reasoned and well-researched judgments and rulings. But there are concerns about how you conduct yourself in your social life, and concerns that you may love the bottle just a little bit more than average. I don't know what you would say about that.
I have recreational facilities, Commissioner, that I enjoy. I wouldn't say that I have done that to the extreme that would cause an alarm. I wouldn't say that.
Okay. But how then do you conduct yourself, at least in your private life, to ensure that there is propriety? There is no, what should I call it, image. You don't create the image of impropriety as a judicial officer.
One of the ways, Commissioner, to do that is to limit your social interactions, as it were, so that you only are where you must be. Yes.
That's it.
That's what I would say.
Okay, thank you very much. Thank you, my lady. I wish you well.
Thank you very much.
Thank you very much for that interaction. I think that brings us to the end of the interview, but before we do so, we always like to ask the candidate whether you have any question also for the commissioners.
Thank you, Chief Justice. I don't think I have any question for the commissioners, just to thank you for the interaction we had, and I thank you very much.
Okay, thank you very much on behalf of the commissioners. We wish you well.
Thank you very
We will
much.
get in touch with you when we complete the exercise.
Thank you very much.
Yes, all the best.